right, David, good to have you on.
Thanks for having me.
So you are studying the ISDS, investor state dispute settlement mechanisms, for a long time, and pretty much, if you want to take us back a little bit, why do you decided to study them in the first place? Because you have done a lot of work on them, and then possibly also like where they're coming from. What was the idea? Obviously, they probably changed a lot over the last decades, and where we today.
So I got interested in investor state dispute settlement when I was really doing trade law. And trade law is probably the dominant pillar of international economic law. And years ago, investment law was a much smaller element. And an older academic said to me, well, investment is really the future. That's going to be a much bigger issue. And that was about 2005 or something like that. And the WTO, which of course is the trade organization, that seems to have had so many troubles in the last decade or so that as an area of academic study, it's been interesting, but there's maybe less interest from students. It's a much more niche area of practice than investment law is. So I've turned my attention to investment law, bilateral investment treaties, which were not terribly well understood, let's say 20 years ago, and the International Center for the Settlement of Investment Disputes, ICSID, which is the chief enforcement mechanism of them. So I thought, oh, that's an interesting area of international law. And I can't claim to have discovered it, but when I started looking at it, there weren't many people that had looked at it. And they were really looking at it sort of as an offshoot of trade and the WTO universe, which had been much more popular, I would say, coming out of the 1990s. But the BITs that I speak of, they've really been around since the 60s, 70s. And they exploded into prominence into the 1990s. And that was really when the arbitral jurisprudence, the case law coming out of these treaties in the ISDS tribunals really took off. And then that became an area of study for international law at that point.
And why are they so important? Like, what's the matter? Like, why are so many people, arguing against them, that they are unfair, not ethical, or whatever? Like, what's the importance?
So I think when you say them, you're probably referring to the treaties, and I think you're right to do so. Why are they needed? Hugely contentious, but they're premised on a link between the existence of a treaty and an increase in foreign direct investment flows into the countries that sign them. It's a tenuous link. It's been studied extensively in various different ways of sort of manipulating the data. And many have said there is no link. I would argue that, and this is based on the trends that I've observed and conversations I've had with multinational businesses, that the treaties do placate investors. It makes them feel safer in countries that are high risk. It makes them feel safer that the assets that they invest in high risk countries will not be seized indiscriminately. And a point that I give as an example that's been made to me many times when I've met business people, if you take an extractive sector company like a mine, it'll be 20 years before that mine produces a profit. So that's 20 years of time of sunk costs that you're committing to that country, and to then suddenly have it expropriated because there's been a change in the government or there's been a revolution or something like that is really quite unfair. So by making investors feel safer, you will then in theory stimulate foreign direct investment, and that is economically valuable because it diverts resources to where they're more profitably used, and added benefits like training, employment, tax revenues for developing countries, and so on. So I would see that the bilateral investment treaty as central to the sort of the developmental project of the 21st century, and really sort of a key component of economic globalization. That would be my standpoint.
Right. No, that makes total sense. And what you mentioned as well, what you mentioned in some of your articles, there are a lot of challenges that were there before, because I think from the business side, it makes total sense. policy volatility is on the rise, especially recently. So you just want to have more certainty. So you want to have the more independent jury out there to solve issues. And obviously, since like some projects can take a long time, that makes sense. But now you had a lot of critics. Can you just like, what are the kind of the most important, let's say, points of the critics, and in how have they been addressed? Because they have been addressed.
Well, there have been many criticisms, and I'm not going to say that they're not valid, because I think some of them are very interesting and are worthy of consideration. The criticisms, I would say, primarily come out of academia, and they're often framed in terms of contrasting the investment regime with the World Trade Organization regime, which is another area that I specialize in, because the WTO has a state-to-state dispute settlement mechanism, but the investment treaties have an investor state, so the investor can bring claims directly against the host state. Why is this so offensive to so many people? Well, it's perceived as being an affront to sovereignty, and the sovereignty that I'm referring to is the sovereignty of that host country's judicial system. You enter a foreign country, you come into conflict with their laws. How do you resolve it? Well, you resolve it in the courts of that country. That's what sovereignty means. Investment treaties, investor state dispute settlements say, no, you're not going to resolve it in the courts of that country. You're going to resolve it in an international tribunal composed of arbitrators selected by the parties, not by judges that are appointed by governments. And in many times, you'll see these hearings being conducted in private and with a less than coherent body of jurisprudence behind them, and some inconsistencies and so on. But it's really this idea of not allowing the host state courts to resolve the dispute, and this being an affront to sovereignty. And I think to many in academia, this is sort of seen as being emblematic of the multinational corporation muscling its way into the rights of the sovereign country, trampling on that country's rights, let's say, to self-regulate, maybe for environmental purposes, health purposes, whatever, and all these legitimate forms of regulation, if you will, being reframed as expropriations. Right. Well, the country wants to impose an environmental law. Oh, well, that's an indirect expropriation, and I deserve compensation for it. So that's the essence of the criticism, and there's definitely some validity in that. But I think the system is improving, and it's becoming a lot more balanced than it was, let's say, 20 years ago.
And how has it changed, like in terms of like transparency and other factors that I'm sure that are really important?
Transparency is probably the big one. In the past, investor state dispute settlement was confidential, as most arbitration is. They're done in secret. Right. The public doesn't know about it. You have your own government taking taxpayers' money and paying off these investors. So the transparency, the improved transparency, having hearings being streamed online, for example, I think did a lot to enhance the credibility. Improving the ability for non-parties or other stakeholders to participate in the hearings. So, for example, labor unions, environmental groups, to get involved in the outcome of the hearings, that helped a lot. In terms of the identity of the arbitrators of the decision-making, having a code of conduct of ethics to ensure that there wasn't bias or sort of maybe a sense of having a stake in the outcome, conflict of interest, and so on. These kind of improvements have worked, I think, to improve the procedure of ISDS. Right. But the backdrop to that, of course, is the improvements to the treaties themselves. And the treaties that you're getting now in the 2020s are much more balanced than the old treaties from the 90s. And they're balanced in as much as the protections for investors are narrower. They're more narrowly framed. So you're seeing narrower definitions of, let's say, indirect expropriation. And you're also seeing enhanced rights for the states, rights to regulate in areas like health and the environment and so on. A expanded essential security provision that is self-judging. So there's much more parameter for a state to assert its sovereignty in a way that can't be challenged then by the investor.
So then I ask you, like, since the signals do not seem to look very good, and who knows what's gonna happen? But at the moment, it seems that like ISDS is not very popular and will probably go out of the window. Is that right? Like, are there any kind of interesting signals that you watch or?
It's certainly declining in importance. And if you see, for example, the new NAFTA agreement, the USMCA,
Right.
ISDS was essentially left out of it. The UK's new free trade agreements since Brexit have been leaving out investor state dispute settlement. So the EU is not including ISDS. It has its own investment court system, which is a little bit more judicialized. It's a bit more like a court system. So classic ISDS seems to be on the wane. However, the CPTPP, the Comprehensive Progressive Trans-Pacific Partnership, does keep ISDS, and some of the other new trade agreements have this sort of holding language, saying things like, well, we're not going to put ISDS, but in the event that we do later on, we're going to have consultations that we might include it. So there's sort of like a holding space, watch this space type of language. And you see that, for example, in the RCEP treaty, the new Regional Comprehensive Economic Partnership, and some of the UK's new trade treaties. So it's not gone. It definitely seems to be less important than it was. If I could make a general statement, I would say it seems to be disappearing from the investment treaties for which developed countries are partners. Perhaps most legitimately so, because these are the countries you might be less concerned about having an unfair court system. You're still seeing it in treaties involving developing countries, because that's where it's most needed, frankly.
Do you see this in, like south to south countries or like, let's say, emerging market to emerging market, maybe apart from China, because China was always a little bit like standing out?
China doesn't seem to want to surrender ISDS, and that's really interesting because China was a bit late to embrace it. It allowed ISDS, but only for certain kind of disputes. And now it seems to be one of the countries that doesn't want to let it go. Japan doesn't seem to want to let it go. South to south countries, yes, you are seeing it in free trade agreements with between developing countries. For example, in the new African free trade area, that has an investor state dispute settlement provision in it. So it's not completely gone, but I think it's definitely beginning to disappear in the free trade agreements with investment chapters in the developed West, I would say.
Right. And when you're talking to, many people in academia and in business, like when they come to you and say, well, where are we going with this? Or if it's now disappearing, the ISDS, mechanism, like how else should I cope with it? How else should I think about it? Just, as a mental model.
Well, isn't that the obvious question? If it goes, what will replace it? So you have the EU's investment court system, which is very similar, except it has an appeal mechanism that has state appointed judges. Untested, we don't know where that's going to go. The EU wants to multilateralize that to essentially have a global court that sits on top of all the free trade agreements. So that's an interesting hybrid. The sense that I get from most academics is that's not terribly well received, and it may end up not going anywhere.
Why
so
is
the
that?
EU, well, I think it will be difficult to get countries to sign on to that.
Right.
Who are these judges going to be? Are they going to have expertise in all these different treaties? The many hundreds or thousands of treaties. How can you have one court sitting above all of them? So again, I think the identity of the judge is how they're appointed. So the EU, rather than abandoning it, wants to formalize it more. So that's sort of an interesting route. If you look at what Brazil is doing, and Brazil was always a reluctant participant to investment treaties. They never really had many. Brazil is really pushing the conciliation and alternative dispute resolution. So Brazil is putting in its treaties about avoiding disputes, this sort of ongoing dialogue between the parties, having a way of diffusing disputes before they escalate, which is a really interesting idea. I'm sure the academics are going to be looking closely at how that works for Brazil. The other thing, of course, is having classic state-to-state dispute settlement like the WTO.
Mm-hmm.
And most of the treaties, in addition to ISDS, have this anyway. So if you eliminate ISDS, well, what do you do if there's a problem? You're the investor, you feel there's been an expropriation of your assets. You go to your home government and you ask them to diplomatic intervention, bring a complaint against the host state. So it's a way of sort of elevating it to the level of public international, like the WTO. I can't see that working pragmatically for smaller companies. If you're a giant multinational that has a huge lobbying office in Washington, D.C., great. That's probably going to work for you. You're a little tiny investor. And let's not forget, not all investors are huge. We tend to think, oh, they're all giant corporations. They're not. You're a little company investing overseas. Are you really going to lobby Parliament in London to bring a claim on it? It's probably not going to work.
Yeah, probably not going to happen. So
I don't know that that's going to work for bigger companies. And then the other obvious answer is the domestic courts. This whole system was designed to avoid that. And I would say again, great if the host state is a safe country with an independent judiciary, rule of law, Canada, Australia, whatever. If it isn't a country like that, you're going to have problems.
And if I know that I'm gonna have problems, like what kind of contract, what kind of deal do I have to strike?
Well, if you're a company that's investing on a larger scale with the host state, let's say some kind of a concession agreement or part of a privatization initiative, you would sign a contract with the host state. And you'd put in that contract, we want investor state dispute settlement. We want arbitration to resolve our disputes. And I would advise any company doing that, and even a smaller company, try to do it. Right. If you don't have the bargaining power, the worst that's going to happen is the host state will say no. I would always try to put in an arbitration clause in any kind of a commercial contract with a sovereign government. And so that's one of the ways that you would ensure the continued use of ISDS. And if I was advising a state, I would say put it in your treaties, sign it, put that into your contract with investors, and put it into your treaties. So that would be my advice. You use contracts where you can, and if you're a country signing a treaty, leave it in.
Are there any interesting statistics or studies that have been done, like how much this, let's call it, to a certain extent, it's an insurance, has paid off, or like how it has benefited companies investing?
All kinds of studies, and the most of the studies have looked at the link between bilateral investment treaties and FDI flows. And to be honest, the studies have been all over the place and not really conclusive. Right. And a lot of studies came out just after the financial crisis in the early teens. And I always felt that was a little bit sleight of hand, because they would get, oh, look at all this FDI from 2008. And look at all this FDI from 2010. Oh, look, there's been a sharp drop. Oh, well, look, the treaty didn't do anything. Well, you're fiddling the numbers because that was when there was a global financial crisis. It's like quoting FDI statistics in the COVID era and blaming it on investment treaties.
Yeah, you have to understand basic statistics for sure.
Yes. If you pick different years, you're going to get a different spike. And I wonder, is it unfair to expect the treaties to necessarily lead to increases in FDI? What about just maintaining FDI? The fact that a treaty can maintain a level of FDI suggests that investors are not scared because there's been new governments or new kinds of regulations. So there's all different ways of looking at that. And we need more studies in that. And I always say, whenever I meet an economist that does statistical work, please do studies, because I can't do it. I'm not a numbers person. I would love to see more on that. The other data that perhaps you were alluding to, because you had asked about investment contracts or putting this in contracts. So ICSID, which is the institution that has a system of rules that does ISDS, it's the leading one. They have statistics on the number of disputes coming out every year and whether they're coming from treaties, the treaty-based claims, or contract-based claims. And interestingly, the number of contract-based claims is gradually creeping upwards. So my theory is, even if every treaty, every free trade agreement, every investment treaty drops ISDS, if it's categorically gone from all the treaties and all the academics are delighted and they all pat themselves on the back for defeating ISDS, it will persist in investment contracts. And again, I would say to an investor, if it's absent from the treaty between your home government and the state you're investing in, put it in the contract. So I think you're going to see it's about 12% now. It's going to be 12, 13, 14, 20, 25, 30, and you're going to start to see a lot more claims coming through ISDS to organizations like ICSID based on contractual clauses rather than on treaties.
Fascinating. Fascinating hypothesis. We will see how it plays out. I would very much agree with that. David, before we are wrapping up, how can people follow your work?
Well, I have a website at City University of London. So David Collins Law City. David Collins is quite a popular name. So David Collins Law City. You can follow me on LinkedIn. I'm on LinkedIn. I have a Twitter account at David Collins Law, where I post my blogs. I blog fairly regularly for a research foundation in the United Kingdom called Politeia. And I'm a member of the Macdonald-Laurier. I'm a senior fellow of the Macdonald-Laurier Institute in Canada, and I blog for them occasionally. So if you follow those organizations, you'll see my blogs. And of course, you'll find my academic writing on my university webpage, my LinkedIn page, and also just a general Google search. Hopefully some of my writings will come up.
Great. Thank you so much, David. Cheers.
Thanks a lot.